Happy 2023. As we enter 2023, more works are going to fall into the public domain. So people are often asking, what does public domain mean? And is it a treasure trove of freely usable works? So when we're talking about public domain, we're talking about intellectual property works. And what we're saying is they're in the public domain, meaning there's no intellectual property protection, meaning if you use it, you can't get sued for a patent. You can't get sued for copyright infringement. That's what we're talking about with public domain. In terms of trademarks, it's slightly different because even though someone might not have intellectual property protection from a registration perspective, they might have continued use, which gives them rights in common law. And how do things come into the public domain? So number one is the registration expires. And that could be for a number of reasons. That could be because of it actually went through its natural life, which, for design patents, 15 years from it registered. For utility patents, 20 years from the earliest priority date. Copyrights, depending upon whether it was a work made for hire, whether the author was known or not. It could be 95 years plus the life of the author plus 95 years. So pretty long times. It really depends upon what type of work it is. But registrations, especially for patents, could also expire if you don't pay the registration fees. That's another way that the registration can expire. In terms of trademarks, as I mentioned earlier, it's slightly different because even if you do not renew your trademark registration, you still might have some rights in the trademark based on your continued use. But if you not only not renew the registration, but also essentially stop using it and abandon those rights, then it might be available for another party to use, even if it is for the same type of product or service. So another way is that the creator of the work or of the invention releases it to the public domain. And that could be done by just them releasing it publicly, especially if it's an invention. If they disclose the invention and then never file for a patent, they lose the right to obtain patent protection. If it's a work, they could just put it under a digital commons license, Creative Commons license, one of those that gives does not necessarily release it fully to the public domain, but just has very limited rights. That's another way. In most cases, governmental works are not eligible for copyright. And then the last category is works that just never were eligible. One of the things we often hear is people coming to us that they have an idea. Ideas have no protection any which way you cut it. Patents are inventions. Those are protectable. Copyrights can protect the expression of an idea, but it doesn't protect the actual idea expressed. So if you write a book about how cars are going to be able to fly, and you get a copyright on that, that doesn't provide you any protection for inventions. Meaning if someone takes that book and then practices what you taught to make a car fly, you can't sue them. Same thing if you talk about a business process or just a theory. If other people learn from that book and use it or talk about it, there's no way to stop them. So that's what we mean when we say works that are not eligible for either patent or potentially for copyright. So just to give you an idea, as this is being recorded in January of 2023, the book Sherlock Holmes is one of the main ones that's being released into the public domain based on it going through the registration and any protection expiring. But there's been many copyrights over the years that have expired, many patents that have expired, that reasons why you have generic drugs is because the patent expires, or why Velcro, hook and loop as it's called, it's not only made by 3M anymore because it's no longer protected by a patent, so other companies can make it. And that goes for a lot of different products out there. You know, there's a famous case of the windshield wipers, and a whole movie about the patent around that. And every car has windshield wipers because now, and does not have to pay royalties anymore because the patent expired. So that's just kind of how public domain works. Things get protection for a limited time. Sometimes it's much longer than others. You know, copyrights last much longer than a patent does. Trademarks can go on for as long as you keep using it and keep paying the fees to renew. And if you like these videos, please subscribe below and let us know if you have any questions. Thanks.